Hello and welcome to another episode of Supreme Court Judgments of the Week on Verdictum. In this segment, we bring to you the most interesting judgments passed by the Supreme Court during the week. Let's begin. CBI versus R.R. Kishore. A five-judge constitution bench of the Supreme Court comprising Justice S.K. Kaul, Justice Sanjeev Khanna, Justice Abhay S. Oka, Justice Vikram Nath and Justice J.K. Maheshwari ruled that Section 6A of the Delhi Special Police Establishment Act of 1942 will become invalid retrospectively, and its application will be considered to be barred since its insertion. In the present case, an FIR was filed on December 16, 2004, and the accused was booked under the Prevention of Corruption Act of 1988. The CBI laid a trap during the investigation in order to get the accused to accept that he has indeed accepted a bribe. The contention of the petitioner was that according to Section 6A of the DSPE Act, the investigating agency required a previous sanction from the central government. The petitioner claimed that the investigation in the matter was thus invalid, due to it being in contravention of Section 6A. The matter was placed before a special judge, who rejected the discharge plea filed by the petitioner. The matter then reached the Delhi High Court by way of a revision petition, which was allowed by it, and the High Court held that the CBI acted in contravention of the said section. The CBI approached the Apex Court challenging the judgment of the Delhi High Court in 2007. While this appeal was pending, the said section was declared unconstitutional by another constitution bench of the Supreme Court on May 6, 2014, in the case of Subramanian Swamy versus Central Bureau of Investigation. The Apex Court held that the said section was unconstitutional and invalid due to it being violative of Article 14 of the Constitution of India. Now the appeal filed by the CBI was placed before the Supreme Court with regards to a provision that has been declared invalid, and the Apex Court is faced with the question whether the striking down of Section 6A will have a retrospective effect. The Apex Court framed the question that whether there can be deprivation of immunity by a retrospective operation of the judgment of the court. If a person will lose the immunity granted to him in case the law has been struck down as unconstitutional. Is there a violation of Article 20 of the Constitution when depriving a person of immunity granted to him? On September 11th, the Apex Court noted that Section 6A of the DSPE Act is merely a procedural safeguard with regards the conduct of investigation, and it does not lay down any conviction for any offence. It was held that the law which is declared unconstitutional, being violative of Part 3 of the Constitution, that provides with the fundamental rights, will be unenforceable since its very inception. And the Section 6A, which was inserted in the DSPE Act on September 11, 2003, was declared invalid since that very day. Religare Finvest Limited versus State NCT of Delhi. A bench of the Supreme Court comprising Justice S. Ravindra Bhatt and Justice Arvind Kumar were faced with the question if DBS Bank can be held liable for the criminal acts committed by the former employees of the Lakshmi Vilas Bank, as the latter bank was amalgamated with DBS. The matter was placed before the Apex Court by way of an appeal filed against the order of the Delhi High Court, which rejected a petition for quashing criminal proceedings filed by DBS Bank. The DBS Bank alleged that it was not responsible for any acts of the Lakshmi Vilas Bank before the same was merged with it. The story began when Religare Finvest filed a commercial suit against Lakshmi Vilas Bank for recovery of a sum of Rs 791 crores. RFL claimed that LVB has misappropriated fixed deposits furnished as security by RFL and its group of companies. Meanwhile, due to high non-performing assets and other financial problems, the Reserve Bank of India placed LVB under prompt corrective action. On 25th November 2020, the central government directed LVB's involuntary amalgamation with DBS, owing to LVB's extreme financial crisis. RFL demanded that DPS be impleaded in the case, contending that criminal proceedings do not automatically abate upon the amalgamation of a company. RFL further claimed that DBS benefited from the assets of LVB, and there is no bar on the transfer of criminal liability onto the transferee bank. The counsel for DBS claimed that before the amalgamation, both the banks had no ties. And it is a well settled principle that only the actual wrongdoer can be punished, and no vicarious liability can be inherited by a transferee company. The top court, after consideration, held that as per clause 3.3 of the amalgamation scheme, only directors and other individuals could face criminal proceedings, and DBS Bank cannot be held responsible for any of the criminal acts committed by the former employees of the Lakshmi Vilas Bank prior to its amalgamation with DBS. The court said that to permit prosecution of DBS for the acts of LVB officials who are in fact facing criminal charges would result in travesty of justice. Basant Nature Cure Hospital and Pratibha Maternity Hospital Trust and others versus Ookaji Ramaji through legal heirs and another. The matter came to the Supreme Court's bench of Justice Bela M. Trivedi and Justice Dipankar Datta by way of an appeal that challenged the validity of a judgment of the Gujarat High Court passed on 27 September last year. The appellants run a natural therapy center by the name of Vasant Nature Cure Hospital and Pratibha Maternity Hospital Trust. Ookaji Ramaji, the respondent in the case, was employed as a watchman and entrusted to take care of the hospitals. He was also given one room to reside in by the hospital authorities. In 1979, the trust relieved Ramaji of his duties, as he had indulged in some illegal activities according to them. Ramaji, in response, instituted a civil suit against the trust, seeking a declaration of ownership of the premises that was allotted to him at the time of employment. He also sought a permanent injunction against the trust from interfering with his possession of the property. The suit was dismissed by the trial court in 1988. Ramaji then preferred an appeal against the trial court order, in which it was held that Ramaji held an irrevocable license over the property, and such license can only be terminated after giving notice of 1 month. The judgment of the above-mentioned first appeal came in 1997. After a second appeal was preferred before the High Court by the Hospital Trust and was adjudicated upon in 2012. Ramaji had passed away during the pendency of the second appeal, and so his legal heirs approached the Apex Court and filed a special leave petition in 2013. The SLP was dismissed as withdrawn. However, after 3 years in 2016, a review petition was filed against the judgment of the High Court by the legal heirs of Ramaji. The same was dismissed for no prosecution by the High Court in April 2016. Thereafter, another application seeking restoration of the review petition was filed, and the same was also dismissed for non-prosecution by the High Court in November 2016. The legal heirs of Ramaji kept on filing restoration applications one after the other and filed such applications in 2017, 2018 and 2019. All the applications were dismissed and even cost was imposed on the 2019 application. The Apex Court in this regard held that no litigation should be permitted to be so lethargic and apathetic, much less should be permitted to misuse the law. The top court also criticized the High Court for allowing such vexatious applications, and that too without assigning a reason. With that, I am Ananya Singh. Thank you for watching Verdictum. Don't forget to subscribe to our channel and download the Verdictum app on iOS and Android for latest legal news.